Welcome to the lecture on forensic psychiatry, the third part. I am Dr. Sanil Kumar MC, working as professor and head of the Department of Forensic Medicine, Government Homeopathic Medical College, Kolt. In the third part of this lecture, we'll be learning about the civil responsibilities of a mentally ill person, then about the criminal responsibility of a mentally ill person, what are the tests that have been done for determining the mental illness, and what are the other pleas that a mentally ill person makes in case of murder. Firstly, we'll be dealing about the civil responsibility, about the management of property and affairs, about mental illness and contracts, then about mental illness and marriage contract, competency of a insane person to become a witness, then about consent and mental illness, and lastly mental illness and testamentary capacity. So about management of property, if a person owns property and becomes mentally ill and he is incapable of managing his affairs with sound judgment, then his relative or his friends can approach the court for judicial inquisition or inquiry. On judicial inquisition, they will be subjected to determination of mental illness, and the medical evidence given by the psychiatrist is in the form of a certificate, and they should state that insanity is of such a degree so as to make him incapable of managing his property. And on inquiry by the court, if it is found that the person is incapable of managing his property, then the court can appoint a guardian or manager who manages the property for the mentally ill depending upon the circumstances. Also, the court may order the sale or disposal of this mentally ill person's property for the payment of his debt and future expenses. Then the court may order a second inquisition if it is reported that unsoundness of mind of that mentally ill person has been seized. Then they can withdraw the guardian or manager who was appointed by the court depending upon the circumstances. So this is about the management of property that is owned by a mentally ill person. Next, about business contract. So if it is proved that at the time of signing a contract, one of the two parties was mentally ill, then the contract may become legally invalid. So at the time of signing the contract, if one of the two parties was mentally ill, then the contract becomes legally invalid. And if the mental illness is developing subsequent to the signing of a legal agreement, then this will not necessarily invalid the contract. So the point of question is that at the time of signing the contract, if any of the two parties was mentally ill or not. So if a mentally illness is developing subsequent to the signing of a legal agreement, that legal agreement will stand and this will not necessarily invalidate the contract. Another point is that if at the time of signing the business contract, the fact that one of the signatories or one of the parties to the contract was mentally ill was not known to the other party, then the contract may not be declared invalid. So if at the time of signing the contract the other party does not have knowledge that one of the signatories of the contract was mentally ill, so that contract may not be declared invalid. So for a valid contract, at the time of making the contract or signing the contract, the person is said to be sound mind. if at the time of making the contract he is capable of understanding it and forming a rational judgment. So this is about business contract and its legal validity. Now coming to marriage, so marriage is considered invalid if at the time of marriage either of the party is incapable of giving a valid consent for marriage due to mental illness. And if at all he is capable of giving valid consent, he has been suffering from such kind or degree of mental disorder as to be fit for marriage or procreation of children, or he has been suffering from recurrent attacks of mental illness. So in these three conditions, a marriage is considered invalid by the law. And if mental illness occurs later in the marriage life, it is not a ground for divorce also. So a marriage is considered invalid if at the time of marriage either of the party is incapable of giving valid consent due to mental illness, or they, though capable of giving valid consent, he has been suffering from such kind or degree of mental disorders as to be unfit for marriage or procreation, or he has been suffering from recurrent attacks of mental illness. Now about the competency of a mentally ill person to become a witness in a criminal proceeding. So a mentally ill person is not competent to give evidence if he cannot understand the necessity of telling the truth due to mental illness. And a person of unsound mind who suffers from delusion, as you have known that delusion is a false belief. So if a person of unsound mind is suffering from delusions but is capable of telling what he has seen, or who understands the importance of an oath, can be considered as competent to give evidence. So this has to be proved by the prosecution or the opposite party that present a mental ill person as a witness. So a mentally ill person is also competent to give evidence during the lucid interval. So lucid interval means a person who is having a mental illness behaving like a normal person. So in a lucid interval, a mentally ill person can give evidence. Then a person of unsound mind, even he is suffering from delusion, but he can't tell what he has seen or understand the importance of oath, can be considered as competent to give evidence. Now about the issue of consent and mental illness. So consent to certain acts like sexual intercourse or hurt is not valid if it is given by a mentally ill person, and if such consent is given by a person who due to unsoundness of mind is unable to understand the nature and consequences of the act. So a mentally ill person due to unsoundness of mind is unable to understand the nature and consequences of the act. So the consent from a mentally ill person for doing certain acts like sexual intercourse or hurt is not valid. Then about the right to indulge in other civil rights such as holding a driving license, voting, or holding office is also lost due to mental illness, because he cannot understand the nature and consequences of his act. And a mentally ill person cannot be a legal guardian of a minor and also cannot adopt a child. So a mentally ill person is not fit for being a legal guardian of a minor, and also he cannot adopt a child. Next, about the testamentary capacity. So the testamentary capacity basically refers to the capacity of a person to make a valid will. Now what is a will? A will is a document detailing the disposition of property owned by a person, which is prepared by him during his lifetime but takes effect only after his demise. And the person who makes a will is referred to as a testator. A will can be revoked or it can be changed any number of time during his lifetime. What is the eligibility for making a will? So it is described in Indian Succession Act 1959. So these following persons are eligible for making a valid will. First, every person of sound mind who is over age of 18. Secondly, an insane person cannot write a valid will unless he is in a lucid interval. An intoxicated person cannot make a will unless it is certified by a doctor that he was under his sense at the time of making a will. A dumb, a deaf, or a blind person can also make a will if he can communicate effectively. Then convicts also can make a will, and the convicts are not debarred from making a will. The procedure for writing a will. So the will must always be in writing. So it cannot be typewritten, or computer print cannot be taken, and it should always be in writing. So sometimes some exception may be provided, as for members of armed forces who are out on an expedition or who is engaged in warfare. In these conditions they can make oral will instead of writing, and this type of will is known as privileged will. Also, Muslims are permitted to make an oral will by the Muslim personal law. There is no particular format for making a will, and it is not even needed to be written on a stamp paper also. The testator, or the person who is making a will, can write a will himself using a fountain pen or a ball pen, and this is known as holographic will. And this will must be attested by at least two witnesses. Neither of them can be beneficiaries. So the two witnesses who attest this will should not be beneficiaries from this will. And it is preferable that at least one witness should be a doctor. The signature or thumb impression of the testator is also mandatory for making will, and the will that is made during his lifetime will come only on effect on the death of the testator. There are some conditions for making will. So the person making a will at the time of making will should be major, that is over 18 years of age, should have a sound disposing mind, have thorough knowledge about his wealth and property to whom he is giving, and that he has a good reason for his action. He must he must make the will voluntarily, and he should make the will without any undue influence, force, or misrepresentation by another person. The will should be signed by two witnesses, out of which one should be a medical man, and none of the witnesses should be a beneficiary from the will. So that concludes about the civil responsibility of a mentally ill person. Now we are moving on to the second part, that is criminal responsibility of a mentally ill person. So a person may plead insanity to avoid three things, that is trial, conviction, and a sentence of capital punishment. So he may plead insanity to avoid trial when the accused is insane and he cannot plead his innocence. Then a person may plead insanity to avoid conviction. Oh, so when the accused was insane when the alleged crime was, at the time of committing the alleged crime, he was insane or mentally ill. Then a person may plead insanity to avoid a sentence of capital punishment when the contempt prisoner is mentally ill. And now about mental illness and murder. So the plea of mental illness by the convict may be raised by the way of defense to any criminal charge, but for more practical purposes, such pleas are confined to charges of murder or gross negligence or grave criminal activities. So as far as a mentally ill person is considered, when he commits a crime, the crime will be purposeless or motiveless in nature. And usually these type of crimes may be committed upon persons usually held dear by the culprit, or occasionally it may be committed upon those who are strangers to him. And its perpetration is without preparedness, without accomplices, or it will not be done in secrecy. So usually the mentally ill person, by reason of unsoundness of mind, he is unable to understand the nature of his act or its consequences, and therefore there will be no motive when he commits violence or murder. And usually the mentally ill person attacks anyone, like a friend, a relative, a stranger, or an enemy, and this attack will be without provocation. So a target for a mentally ill person during a crime is not definite, and sometimes he may also commit multiple murders also. And regarding perpetration of crime because of unsoundness of mind, he does not know what his nature of action and its consequences, and usually the attack made by the mentally ill person is spontaneous, and there will be no accomplices or any person who is assisting his crime, and there will be no selection of time and place, and there will be no attempt to run away from the scene of crime, or he doesn't keep anything secret. Now about the test for determining insanity. The first and foremost test is about McNaughten Rule, and in case the McNaughten Rule states that an accused person is not legally responsible if it is clearly proved that at the time of committing the crime he was suffering from such a defect of mind that he does not know the nature and quality of the act what he was doing, and that what he was doing was wrong. So if it is proved that at the time of committing the crime he was suffering from such a defect of mind, or he is suffering from a mental illness, that he does not know the nature and consequences of the act, or he does not know that he was doing a wrong act. There is a history behind McNaughten Rule, because McNaughten is a person, and he was accused in a murder case. And he was a person having a delusion of persecution, and under this delusion of persecution he shot Dr. Drummond, who was then the private secretary of Prime Minister Sir Robert Peel in London. So after shooting Dr. Drummond, Mr. Drummond, the person McNaughten was arrested, and he was uh, he has to undergo a trial. So the verdict of the trial was that he was not responsible by a reason of insanity. After this, a lot of discussion was followed in the court by a 14 judge bench, and later in the parliament, and this led to the formation of rules that was termed as McNaughten Rule for criminal responsibility of insane person, and this rule, McNaughten Rule, was formed in 1843. And states that he was unable to know the nature and quality of its acts due to mental illness, so he was not held responsible for the criminal act. The adaptation of McNaughten Rule to I.P.C is section 84 I.P.C, and it states that nothing is an offense which is done by a person who at the time of doing it by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. The next rule is about Durrham rule. So it states that an accused person is not criminally responsible if at the time of committing the act he did not have the capacity to regulate his act to the requirements of the law as a result of mental disease or defect. So Durham rule states that a mentally ill person who does not have the capacity to regulate his conduct to the requirements of the law is not responsible for the criminal act if at the time of committing the act he does not have the capacity to regulate his conduct to the requirement of law, and this should be a result of the underlying mental disease or mental defect. The next test is about irresistible impulse test. So an accused person is not criminally responsible if he knows the nature and quality of his act, and that knows that it is wrong, if he is incapable of restraining himself from committing the act because the free agency of will has been destroyed by mental disease. So any act done in impulse, and this person's thinking capacity has been destroyed by mental illness, and he is having a habit of becoming an impulsive person, and he does an act which he knows that it is wrong or against the law, but he uh, he is incapable of restraining himself from committing the act. It is irresistible impulse test, and in this case the accused person is not responsible. The next is about American Law Institute test. This states that a person is not responsible for his criminal conduct if at the time of committing such an act, as a result of mental disease or defect, he lacks adequate capacity either to appreciate the criminality of his conduct to the requirements of law. So here also, uh, if he lacks adequate capacity either to appreciate the criminality of his conduct to the requirements of law due to the underlying mental disease or defect, he is not criminally responsible to the criminal conduct. Now we are coming to the last part, that is criminal responsibility in some special situations. The first special situation is about automatism. So in automatism, it is a conduct of a person whose consciousness is impaired to such an extent that he is fully not aware of his action, or his action is automatic, and some diseases that produces automatism includes epilepsy, concussion, hypoglycemia, somnambulism, etc. So in these disease conditions, it produces automatism, or the consciousness is impaired in a person, and he is not fully aware of his action. So in this condition, he is not criminally responsible. Some other pleas may be made in murder, like somnambulism, somnolentia, impulse, hypnotism, or mesmerism, delirium, drunkenness, etc. So somnambulism is basically walking during sleep, and he's also doesn't have any awareness of his action during somnambulism, and he will not be remembering it later. So any criminal act done during somnambulism, he is not responsible for his action. Usually in case of somnambulism, he leaves bed, goes away, and he is not asleep, but is in a state of dissociated consciousness. Uh, in somnambulism, his mental faculties are highly concentrated on a particular idea, and he may solve problem during somnambulism that defied him during waking hours. During waking hours, he was not unable to solve a problem, but in somnambulism he will find an easy way to or easy solution for this problem. Later he may commit suicide during somnambulism, or he may meet with an accident. Another condition is called somnolentia. So somnolentia means it's a state midway between sleep and waking, with the mind being in a confused state, and therefore if any crime is done during somnolentia, this person is not responsible for it. Next is about impulse, and you all know that impulse is a sudden and irresistible force which compels the person to form a conscious performance of act, and these acts are without motive or forethought. So as long as a person is able to decide what is right or what is wrong, the irresistible impulse is no defense plea. Then about hypnotism or mesmerism, and mesmerism means persons who are acting according to the suggestions made by the hypnotizer. So in hypnotism or mesmerism, the patient or the mentally or the persons behave as per the desires or command by the hypnotizer. So, if a crime is committed during hypnotism or mesmerism, that person is not responsible for his actions. And hypnotism or mesmerism is used to treat conditions like depressions, mental disorders, anesthesia during as an anesthesia during childbirth or during dental operations, and it is done in hysterical paralysis, aphonia, asthmatic attacks, etc. So in hypnotism or mesmerism, he is not responsible for his actions. Next is about delirium. So you know that delirium is a problem in the consciousness of the person, and he is having acute confusional mental illness, and delirium is usually characterized by clouding of consciousness, and he will show incoordination in his movement, he will have disorientation, and he will be having abnormal experiences such as illusions, delusions, and hallucinations. In this state of delirium, these persons may have suicidal tendencies, and they may become impulsive, and also they may commit murders. As a delirium person is considered as incapable of knowing the nature of his act, he is not responsible for criminal act done during the period of delirium. And lastly, about drunkenness. In case of drunkenness, a person is not responsible for his act if the intoxicant was given without his knowledge or against his will. That is also known as passive drunkenness. So the intoxicant was given to this person without his knowledge or against his will, and if he commits criminal act during this passive drunkenness, he is not responsible for his criminal act. And also during insanity produced due to alcoholism or delirium tremens, he is not responsible. That is explained in section 85 and 86 of I.P.C. However, if the person drinks voluntarily and become intoxicated, it is no excuse for commission of a crime. So in passive drunkenness, he is not responsible, but in voluntary intoxication, he is responsible for his criminal act. So we are coming to the end of the third part of forensic psychiatry, and the topics discussed today were civil responsibility of a mentally ill person. Then we explained about the criminal responsibility of a mentally ill person. Then what are the tests for determining mental illness, like McNaughten Rule, Durrham test, irresistible impulse test, etc. Then other pleas that are made in murder, like automatism, somnambulism, somnolentia, delirium, drunkenness, etc. Thank you.